Hello and welcome, everyone. My name is Stephen Armstrong, and I'm the president and co-founder of Maple Business Council. And it's my pleasure to welcome you to our webinar today from Orange County, California. We are proud to be co-hosting this event with Fasken, a leading Canadian law firm and a renewing member of Maple. We hope everyone is staying healthy, and we appreciate that you've made time for today's program. Slide. The focus of our content today is on cross-border M&A and key tax considerations for doing business in Canada in the context of COVID-19. We have a lot of timely information to share with you today from a distinguished panel of speakers that we hope will be helpful to your business planning. Slide. For those of you who may not be familiar with Maple Business Council, we are a networking organization focused on growing the economic ties between Canada and Southern California, where Maple is based. There is tremendous economic activity between our markets, with Canada being the second largest export market for California, has the largest diaspora of Canadians worldwide. We connect business leaders from across sectors through events in Canada and Southern California, and through a variety of online content platforms. We have led business delegations to Vancouver and Toronto, and we are a partner to the various economic development organizations that are on both sides of the border. We also work closely with the Consulate General of Canada in Los Angeles and the Consulate in San Diego. Next month, Maple will be celebrating our 5th anniversary. Slide. It's now my pleasure to introduce our moderator today, who is also someone that my co-founder, Robert Kelly, and I owe a debt of gratitude for encouraging and supporting the launch and growth of Maple in Southern California, James Villeneuve. Currently a senior business advisor to Fasken, Robert and I met James shortly after he became Consul General of Canada for Southern California, Arizona, and Nevada in 2014, a post that he held for 4.5 years. Prior to this, James held senior management positions with Anheuser-Busch InBev in Canada, Europe, and the US, responsible for North American and global corporate affairs. So it's now my pleasure to turn our program over to you, James.
Thanks, Stephen. And I want to thank you and Robert for forming Maple. I remember those early days when we were trying to get a business group organized in Southern California, and the two of you really stepped up and have made it, I think, one of the premier business associations in the United States. So congratulations, and it's an honor to be part of this seminar today. I want to just reference the consulate quickly too. I know some of the members of the consulate staff are on this call today. I reached out to the Consul General, Zabe, a week ago. He's on another call today and could not join us. When we talked about the reason for this call, I think it's pretty important. If you dial it back, 2.5 months ago, life was normal. Now it's not. And the Canadian border closure, which has now been extended through June 21st, there's a bunch of factors to that, but not the least of which is Canadians concerned about the high level of numbers in the United States. But the border is one that has been a flow of commerce since the two countries were founded. Literally thousands, if not hundreds of thousands of people operate on both sides of the border, whether it be businesses, families, home ownerships, you name it. So it's important that we try and get things back to normal as soon as we can. It's also the largest trading relationship in the world, so it's important for both sides of the border. One of the interesting comments that our Canada's ambassador made earlier this week, Kirsten Hillman, was to talk about supply chain security as a North American opportunity. So clearly, if you're doing business in both Canada and the United States, that would be the goal, I believe, of both countries down the road. Fasken, we've assembled some of the partners here that are experts in their fields. The only thing I'll say is if there is something that you didn't have addressed today, because we're just covering a couple of topics, you can reach out to us and we can redirect within the firm if you have other questions in other areas. So with that in mind, I'd like to introduce our 3 Fasken partners on the call. Gesta Abols, Neil Kravitz, and Claude Jodoin. And I'll turn it over to Gesta, who will talk a little bit about the firm and then get into M&A as one of our key topics today. So Gesta, over to you.
Thank you. Thanks, James. Next slide, please. And the next slide after that. So just a little bit on Fasken. Our history goes back to 1863, so we've been around a while, but we really embrace sort of technology, have made investments in AI tools to help deliver services more efficiently, both on the document production side and the due diligence side. We're a large law firm with over 750 lawyers, and as it relates to Canada, we're in every major commercial center, with leading practices. If you go from west to east in Vancouver, in Calgary, Toronto, and Montreal, there are more offices, but those are the major centers. In terms of our sort of national footprint, maybe one way of demonstrating that is we were recently selected as the official partner of the Canadian Olympic Committee. So we're excited about that. It's unfortunate the Olympics are delayed, but it's a partnership we're really proud of. Neil and I are both M&A lawyers. We're going to talk about the M&A subjects. We're also the co-head of our U.S. Outreach Committee. We do not practice U.S. law. We don't have a U.S. office, but we really value our relationships with U.S. Business folks and their advisors. Claude is from our tax group, and he will be speaking on those matters. Next slide, please. So on the M&A bit today, Neil and I decided to divide it in half. He's going to give you a bit more of the forward-looking insight, dealing with the specifics of the pandemic. But we wanted to give you a brief overview on what M&A in Canada is like, just in case anyone today doesn't have experience doing deals in Canada. The good news for our American friends is that M&A in Canada is virtually identical in terms of what points get negotiated, what the data points are as in the United States. But there are a few noticeable differences that I think for the most part are positive, at least from the purchase of a perspective, of a buyer. So at the top of the list, and maybe this is the tail wagging the dog, but it is a stark contrast, is on public M&A deals, there is virtually no litigation. Why that's the case is beyond the scope of today, but as a potential purchaser, that's a good fact. The other element is if your approach is rebuffed and you're dealing with a public company, making a hostile bid, although the rules were amended in the last few years, it's still much easier in Canada than the United States. A board, for example, in Canada cannot simply put a rights plan in place and leave it there indefinitely. So, once a bid is launched, the odds of a transaction are quite high. If that's something one is interested in, Fasken also has the market-leading study on hostile bids and all the data points, and we can share that with you after today's webinar if that's of interest. The other thing I wanted to mention, because it's been getting a fair bit of press in the US, is this idea of a stakeholder governance model and a move to enhanced ESG and thinking beyond the short term and all the affected stakeholder groups. So that's something we've been living with in Canada as a matter of law, not as sort of an aspirational movement for some time. It's been over 10 years since a Supreme Court of Canada's decision came out that clarified with no gray area that directors need to focus on what's in the best interest of the company and consider stakeholders, and that shareholders don't have sort of primacy in that consideration. As a practical matter, the sky has not fallen. I don't think it has led to abuse by management and boards under the guise of some complex cover, but we've been living with that. And I thought that's interesting for you to share with you. It is true in Canada that we tend to follow certain practices that you see in the United States. One is the use of rep and warranty insurance on private deals. So I would suggest pretty much every experienced M&A lawyer in Canada has maybe done a deal, a few deals with rep and warranty insurance. It's now considered on every deal. And when I speak to my friends in the United States in the same space, it strikes me that on private M&A, rep and warranty insurance is almost a de facto part of the transaction. There are differences that are worth bringing to your attention. The main one I would say is on labor. We don't have sort of an at-will employment concept. So if you're looking to do a deal and you're not sure you're going to keep all the employees and you want to figure out what that might cost on letting people go, the severance entitlements, if they haven't been considered carefully, can come up as a big surprise. But beyond that, the actual technical aspects of affecting public deals is different. We use something called a plan of arrangement, but that's our one-step transaction process. It's a court-supervised process, and it's often used. Part of the reason is that from U.S. perspective, if the consideration that's going to be issued on a deal includes shares and they're going to fall into the hands of U.S. security holders, there's a U.S. exemption because the transaction is approved by the court. If it's a related party deal, we don't have the concept of entire fairness that you see in the United States, but we have a rule that is very similar in terms of process, minority approval, and the rest of it. So from a technical standpoint on M&A, I think the key message would be that there's a lot of similarities. The speed of deals is very similar. I don't think you're going to be banging your head up against the wall wondering why just the culture of M&A is so different than it might be in the United States. And hence you see a lot of north-south and deals and some the other way. And then I guess as a last point, really going high level, what are Canadian markets all about? Canada's a very diverse economy. There's certainly a lot of mining companies based in Canada, and you see a lot of those out of Toronto. Oil and gas, which is a sector that has really taken it on the chin in Canada, but the oil reserves in Canada are amongst the largest in the world. Sophisticated financial markets, banks, financial institutions such as Brookfield, Onyx, the pension funds who do direct investment, they're big factors. And you have a really well-educated population with a lot of tech companies and other entrepreneurs building businesses. And something that is familiar to our friends here in California, but cannabis has been legal on a recreational basis across the country under federal law. And so our capital markets, in fact, have a large number of very significant cannabis companies. And so that's an interesting differentiator to a lot of other places. So with that, that's a very brief and high-level overview. Delighted to take questions now or after. And with that, I turn it over to my friend and partner, Neil.
Thanks, Gesta. If we could just advance the slides, please. So looking to what we're seeing now and what we might see in the near to medium term, distressed M&A activity in Canada, probably quite similar to what people are seeing in the United States. Certainly the methods that are used to do M&A in distressed situations are quite similar. You have your prepackaged deal. You might have your loan to own where somebody takes a secured position in the assets to effectively control the assets as they come out of the distressed situation. Or you might have a stalking horse bid that's put in. So all those aspects are quite similar. Our insolvency and bankruptcy law is not that different from the US, and there have been a number of significant cross-border restructurings, and there are a couple of retailers that have filed for protection recently in Canada. So we might have more specific things to talk about in the near future on that front. But the mechanics and the way the deals are done for distressed situations are pretty similar. As far as hot topic situations for M&A, one of them has certainly been material adverse change clauses or material adverse effect clauses, and whether or not COVID-19 should or could represent a MAC in certain situations. Gesta explained mechanism that we use for some of our M&A transactions. I would say for public deals, it's probably higher than 90% that a plan of arrangement is used for a couple of reasons. One is the 3A10 securities law exemption that you get on the US side of the border. The other is that plans of arrangement give a lot of flexibility for tax planning, for dealing with option plans and other securities. So certainly almost all of your private equity deals are done by way of plan of arrangement. We have one case right now before the courts where parties alleging that there's a material adverse change in the context of COVID-19. That is actually in a plan of arrangement transaction. So just so you understand the context, in a plan of arrangement situation, the parties have to go to court twice. Once is only for process, so it allows the parties to say, we're going to mail information to the shareholders on this date, hold a shareholders meeting, etc., and you get the blessing of the court to do that. The second time you go back is for what's called the fairness hearing, so that's right before you close, and you get the court to say that the transaction is fair from a financial point of view to the shareholders. The odd cases in public M&A where parties don't want to use a plan of arrangement is where you might have stakeholders who have a problem with the deal because it gives them an automatic forum to show up in court and file a contestation to the deal and be heard by the court. That's happened a number of times. So there's a strategic decision to be made. All this to say that the one case in Canada right now before the courts where the parties are claiming that there's a MAC is in the context of a plan of arrangement situation, and the parties tried at the court hearing on the fairness to stop the transaction. The court, not surprisingly, determined that they need to hear more evidence as to whether there is or is not a MAC in this situation. Like a number of things in general, both culturally and on the legal side, and in this particular instance, Canada tends to follow the US. And when I say US, it's often Delaware. So the Delaware cases that have been heard in the past on material adverse change will certainly influence what's going on in Canada as they would across the states as well. So we're waiting to see what happens there, but we're not expecting sort of a flood of cases where MACs are alleged. Other factors to consider is they really come down to allocation of risk. So in a lot of deals, in all M&A deals, it's really about allocating risk between the parties in terms of representations and warranties and indemnification and what have you. That is more acute in the COVID-19 situation. So normally, to take a primary example, if you have a two-step closing and you have covenants where the target will usually take on the obligation of running the business in the ordinary course in between signing and closing, that becomes more complicated in the COVID-19 situation. First of all, you have to ask yourself, well, what's the normal course in the time frame? There might be a lot more specific negotiations about interim covenants, specifically with respect to COVID-19. Those could be operational as to what steps the company's taking to make sure that their employees are safe, that their customers are safe. Normally, that would not be a concern, but a buyer who ventures into an M&A deal now will want to know that they're taking on as little risk as possible. So they want to make sure that there's as much protection there in terms of a lawsuit going forward. That might be financial. So if the target has a credit facility, for example, and has certain ratios that it needs to meet, those might be in danger, and a buyer will want to know what the target has or has not done in terms of renegotiating with the bank or getting some relief from the bank. I would say that there are a couple of other examples. Everything that's quote unquote normal in an M&A situation is going to be treated a little bit differently in the COVID-19 situation. So whether it's closing conditions, price adjustments, earnouts. So an earnout would normally be a very customary and normal thing where if the business hits certain targets going forward, it's based on past performance and normal projections of management. So what does that mean in the COVID-19 situation? The parties might spend a lot more time figuring out what those milestones should be. It's obviously going to be different industry to industry, but there's going to be a lot more negotiation, a lot more time taken in terms of how deals get done. The other parts that lead up to signing up a deal, due diligence will be quite different. Certainly in private equity deals, the private equity firm likes to go sit down with management meet the team, depending on the type of business, actually walk the floor of the business that they're buying rather than just get numbers. So that's certainly a challenge. Getting back to rep and warranty insurance that Gesta mentioned, the providers of the insurance do their own due diligence and ask management their own questions. So they might be looking at things a little differently and through a different lens for COVID-19 as well. So, while the very mechanics of the deals, those are all the same, different aspects are going to draw more attention in the current circumstances. So happy to take more questions on that. And I'm going to turn it over to Claude Jodoin, who's a senior partner in our tax group. We'll speak to some tax aspects of the current situation.
Thank you very much, Neil. Good morning, everybody. As mentioned, my name is Claude Jodoin. I'm a tax attorney practicing mostly in transactions with a particular emphasis on cross-border transactions and technology companies. And as of late, I should say, I've become an expert in tax measures relating to the COVID-19. It's a privilege to be with you today to discuss the opportunity, to have the opportunity to discuss with you these measures arising out of Canada's response. And my discussion will be divided in three parts. The first being a general overview of certain of the measures. The second will be a brief discussion on the main program that will be of interest to you. And the third will deal with certain income tax issues that arise directly from the COVID-19 and administrative relief that's been provided by our tax authorities. So the first segment, the response of the Canadian government has been to provide measures to come to the aid, on the one side, to individuals that were impacted directly by the COVID-19 situation, namely loss of income, loss of jobs, and provided for an economic package for individuals that resulted in $500 a week payments for 16 weeks. And those will not be the subject of our discussion today. We're going to look at the other side of the equation, namely the measures provided to the motors of the economy and the employers who had to either shut down or postpone their activities. And the response there from the Canadian government have been manifold, almost daily changes. If you can go to slide 3, please. So this slide provides a bird's eye view of some of the main measures. And we can see in order, we have the first one being a measure designed to help out landlords whose tenants are obviously unable to pay and provides for certain financial support. We have a second measure that provides for small business loans, again, for small businesses that were impacted. And the last two, which are the focus of our discussion today, are wage subsidies. So the number 4, please. Next slide. So the first one is a 10% subsidy. That was the first announced, and perhaps was devised at a time when the estimates for need for help were rather conservative, and provided for a 10% subsidy of salaries paid. And most employers qualified, except for corporations that were not under Canadian control. And so the program had very limited appeal once you went through the technicalities. It was unavailable to large corporations and those that were not under Canadian control. Slide number 5, please. So the main program that was adopted as a result of the relative, if we should say, mitigated success of the first program is what is called the Canadian Emergency Wage Subsidy. Now, this is an important program in that it's a program that's computed on the basis of salary paid in a period starting on March 15, and was designed to run for 16 weeks, thus from March 15 up to June 6th. The amount of the subsidy is roughly 75% of salaries paid. So the idea there is that the Canadian government was trying to encourage employers to maintain the employer-employee relationship by providing an incentive that would cover 3/4 of that person's salary. Now, in some circumstances, if the employer did not top up, if you wish, the 25% missing, you could end up in a situation where the full amount of what was paid to the employee was covered by the subsidy. So the goal was to encourage maintaining the employer-employee relationship. A few points here to underscore for you, especially in light of certain programs in the US. The first element is that there is no limit as to the number of employees that may qualify for this program. So any employer, whether it has 1 employee or 10,000 employees, would still cover, and each employee that is working or is under an employment relationship with that person would qualify for the subsidy. So thus, there is no cap on the amount that a person could expect to receive, other than the 75% limit that we talked about. But globally, there is no monetary cap on the amount that would be paid to that employer. Now, the conditions to deal with, to qualify for this aid is that you have to be in presence of what they call an eligible entity that has suffered a revenue loss and is in reference to a reference period and has employees during one of those qualifying periods. A lot of technical elements that we tax lawyers live on. But if you can turn to slide 6, please. Okay. So the first element is to see now who would qualify, and this is a crucial element, because essentially the employer has to be a qualified entity, and the definition is widely drafted to cover almost every situation and all forms of employers, which would include taxable corporations that are either big or small, whose shares are privately owned or publicly listed on a stock exchange, a Canadian corporation, whether or not controlled by Canadians or non-residents, and would include as well a non-Canadian entity, non-Canadian corporation that carries on business in Canada and has employees. So that's the key element, is to have in Canada an activity that would require employees. Now, certain persons are excluded, specifically, technically, persons that are exempt from income tax in Canada. So by way of example, a non-resident entity that is carrying on business in Canada would not be subject to tax if it doesn't have a permanent establishment in Canada and can rely on a tax treaty to exempt that income. The particular technicality here is that the person is in fact carrying on business in Canada, is subject to income tax, so it's not exempt, but is entitled not to pay tax in Canada by virtue of a tax treaty. So that would make that person still an eligible entity, which I think is an extremely important element for you to consider with respect to either your colleagues or your corporations that you deal with. Slide number 7, please. So as mentioned, the whole program is divided in terms of qualifying periods and reference periods. So the original plan was to have a 12-week program with 3 qualifying periods that are identified there as 3 4-week periods. So the way it would operate is that a person who has an employee in, let's say, qualifying period 1 would be entitled to claim the subsidy to the extent it meets other requirements, And one of those requirements is that you have to look at the reference period for that particular qualifying period to determine whether or not you meet the revenue loss criteria that we will get to in a moment. So the revenue loss issue is that for a reference period, so as you notice, we put March 2020 versus March 2019. So the idea is that to determine whether or not you qualify, you have to be in a position where your income for March 2020 as compared to March 2019 has significantly decreased. The case of March is by 15%. With respect to April and May, the comparison is done, but the criteria is that your income must have gone down by 30% on those bases. That would give rise to the opportunity to claim for the corresponding qualifying period a subsidy for employees that you have during that period. Number 8, please. This leads us to administrative relief and other matters. I think we may have skipped a slide here. Can you go back that one? No. I guess there's a slide that was skipped somehow. All right, so we'll go to that one then. So this segment is important, and if you allow me to go through it, this will deal with particular issues that arise directly as a result of what's happening in the world with COVID-19. So, for example, an individual Canada imposes tax on individuals that are resident in Canada, and as is the case for many countries, residence is a question of fact, but is also a question of where the person physically is and resides for a number of days in the year. A person residing or present in Canada for 183 days would be deemed to be a resident in Canada, subject to the applicable provisions of a tax treaty. So you may find yourself with individuals that, due to travel restrictions, are not able to return to their country of residence. And so these accidental tourists would become, accidental residents in Canada in that they would be here for more than 103 days and be caught and deemed to be a resident of Canada. Our tax authorities have taken a position of saying that a person who ordinarily resides in another country intends to return, but is required to stay in Canada by virtue solely of travel restrictions. Our tax authorities have agreed not to count those days in the computation of the 183-day limit for deemed residency. Now, at the corporate level, you have a similar issue. A corporation that's established under foreign law, which either could be used by a Canadian resident for purposes of tax planning involving activities outside Canada, or in the context of non-resident companies doing business in Canada, the issue arises as to where that company would be controlled. So we would find ourselves with a situation where under tax principles, a company is considered resident somewhere where it has its central management and control. So today, as it turns out, with certain elements that would require a person to be unable to travel due to travel restrictions, you may find yourself with board meetings taking place in Canada because, or by reason of these travel restrictions, as the board members would be unable to return to their country of residence, and have essentially created the possibility that central management and control of the companies would be in Canada, and the company could be viewed as resident in Canada for purposes of income tax. Again, we find ourselves with CRA taking the position that with respect to countries where we have a tiebreaker rule, they would expect the ability to rely on the tiebreaker provisions that should sort this thing out, which might be true for treaties like the one we have with the US, where we have S corps and C corps that under the tiebreaker rule could determine the issue as it should be. Other tax treaties look for the place of effective management. That could be an issue where a director must take part in a board meeting in Canada due to travel restrictions. So CRA has determined that it would not consider, in these cases, the corporation will become resident in Canada solely by reason of the board having to meet in Canada due to travel restrictions. The next element that you see up there is carrying on business in Canada through a permanent establishment. Now, I mentioned the rules for non-resident companies carrying on business in Canada and their eligibility for the wage subsidy. What is also important is for these entities, in their structuring, they may have taken the view that they don't have a permanent establishment in Canada and thus could rely on the tax treaties where they can carry on business in Canada without being subject to income tax on the basis that they do not have a permanent establishment in the country. Now, the manner in which they have to carry out the claim for that exemption from taxes by filing, but the issue can arise now that by virtue of being present in Canada and having their employees that would normally carrying out their duties in a country other than Canada could be viewed as having those activities that could result in a permanent establishment and could create a permanent establishment in Canada. CRA has stated that as they did for purposes of determining residence of an individual, they would not be counting the employee's number of days in Canada for purposes of determining residence, and as a result, the corporation would not be encountering the creation of a permanent establishment in Canada. A similar issue arises with respect to cross-border employment, because employees that are not resident in Canada would normally not pay tax here on their employment income to the extent that they either earn less than $10,000 or are not present for 183 days in the year. As was stated in the first example, CRA has also taken the view that for this purpose, the days in Canada because of travel restrictions would not count against 183 days. I think that would be the end of my presentation, unless you have questions.
Great, thanks, Claude. We do have the opportunity to take a few questions. If anybody has any, they can submit them and I will ask them. And we do have a few that have come in already. So first question is from Tina, and it's, what are the cross-border tax considerations if a US Inc. or LLC buys intellectual property from a Canadian LLC or Inc.? Claude, can you take that?
So repeat that again.
Sure.
A US LLC?
Yeah. What are the cross-border tax considerations if a US LLC buys intellectual property from a Canadian LLC?
All right. So first of all, we don't have LLCs in Canada. We have ULCs, which are treated as corporations. I think that the topic would require a little bit more than this 2-minute discussion here, but I can tell you there are a number of issues that arise. Mainly, if you're buying IP from Canada, there might be withholding tax from a perspective that it can be used in Canada. And the LLC itself would be viewed as a corporation, so I don't know if the two are related or not. But if you wouldn't mind, just send me more information and I'll be happy to guide you on that.
Okay, great. Thanks. Couple more tax questions. Can the emergency wage subsidy in Canada actually represent the entire salary of an employee?
Well, yeah, in fact, it can, because as I only alluded quickly, the formula of the 75% is that the government wants to provide a subsidy equal to 75% of the salary. And there's a concept of baseline. So basically, baseline is the income the person was making prior to March 15th, so prior to the COVID becoming an issue. And the reason for 75% was that the government said, we will kick in 75% if the employer pays the other 25%. And when the rules finally came out, the 25% never materialized as part of the legislation. And so you find yourself with a situation where you compare what the person was earning before March 15th and after March 15th. And if what you're paying after March 15th is at least 75% of what they used to own, the entire salary of what you're paying post March 15th would be covered by the subsidy. The employer would only have to cover employer-related taxes. And if the person is actually only employed but stays at home, so leave with pay, the employer is relieved from paying any kind of employer contributions for the pension plan. So that's
Okay, thank you.
a short answer.
Maybe over, and just to the M&A team quickly, we have a question. Are there any trends or opportunities in Canada that may be interesting or present some timely opportunities for foreign investors at this time?
I'll take that question. I talked about in my overview of Canada, I mean, to me, the one area that really jumps out is, if you have the appetite, is the oil and gas sector. Due to global trends and issues, prices have come off their high, and that's affected operators everywhere. But Canada has been uniquely hard hit. There are some issues for the industry in terms of getting product to market that are slowly being resolved through building of additional pipelines. So I think in the long term that's a good development. But there's also, again, if you want a contrarian sort of opportunistic move, particularly European investors have blacklisted Canadian oil and gas producers, I think unfairly. And so they need capital. The prices have been beat up. I think there is a long-term play there if one's willing to sit through some noise. So that's the one that jumps out as most obvious to me. The other sector I mentioned, there was excuse the choice of words, but there was a real high when we were heading up to legalization, and now there's been some rationalization. But you do have some really massive companies in terms of production capacity, and whether it's through consolidation or bringing in some experienced management teams as they shift from sort of entrepreneur builder to operator. I think there's real opportunity there that is unique to Canada. And then when you're in a time of uncertainty, gold, a lot of people are, especially with additional monetary stimulus globally, concerns about inflation, gold as a safe harbor. So there's a lot of Canadian gold companies with assets globally that are there, and the juniors in particular still haven't really seen their values run up. So those are three where I take my legal hat off and put my investment banker hat on and say those are three areas that may be of interest.
Okay, we have a couple linked follow-up questions to that, but do the Wet'suwet'en protests cast a pall on prospects of acquisition of Canadian resource extraction companies from U.S. investors? Any thoughts on that?
I mean, look, there's a lot of noise for sure, some uncertainty. but at the end of the day, there is a process to move forward, and you can get deals done, and you have to have a strong stomach and be willing to potentially face some noise in the media, but Canada is trying to find the right balance on consultation. That's a very complicated legal issue, but projects can happen, and through experiences like that, I think they'll be done more effectively. But it is a challenge, to be sure.
Okay, we have time, I think, for one more question. How do you see deal dynamics and flow in the next 2 quarters?
Yeah, it's Neil. I can take that one. Alluded to this a little bit when I was speaking before. Other than some opportunistic deals that might take place, so if there's a large opportunity for a public company in a particular industry, you might see that go relatively quickly. But I think you'll see parties proceed with more caution, certainly on the private M&A front and private equity front in terms of due diligence, negotiation. I mean, there are certain industries where it's just going to take longer than others for activity to come back, where there's a high level of uncertainty, whether it's real estate or travel, hospitality, and what have you. There may be some that move more quickly in the technology space, product delivery, food delivery. There's some rumblings about some transactions that might take place in those areas more quickly, but I think you'll see parties moving along with caution. Certainly, in terms of being a seller right now, people who hold private businesses that were rubbing their hands together or waiting to cash in on a good valuation, might be a little. I mean, timing's everything, like a lot of other things in life. So I might see themselves on the negative end of that, and that might take a while. So, I mean, in general, people proceeding with caution, dipping their toes, see what industries they're comfortable with. And then on the private equity side, a lot of them have to manage situations for their own portfolio companies before they really jump back in. So we think it's somewhat of a slow progression with kind of pop-ups of more opportunistic deals here and there.
Okay, great. Thank you. Well, that concludes our session. I appreciate, I'm going to turn it back to Stephen in a second, but I just want to thank everybody that's dialed into this and asked questions. And the intent was not to cover all of the issues you would have in terms of doing business in Canada, but to give you a flavor of it. But I can tell you that if you're looking for help in Canada, that on pretty much any issue that you need, Fasken can provide that to you from coast to coast. So feel free to reach out to us if you have any other follow-up questions to this seminar or any other issues. And this is a fluid topic, meaning things are going to change over the next period of time, so your businesses may have to adjust as well. So we're happy to help. Stephen, back to you.
Great, thank you, James. And I just want to echo your comments. Thank you to Gesta, Neil, and Claude for your insightful and timely perspectives, and to everyone who made time today for this event and for your excellent questions. Did want to point out that there are some great resources online, as you see on the slide, not only the Fasken website itself, but also the Fasken Institute COVID-19 Knowledge Center, to which new content is added regularly. And if you would be interested in learning more about Maple Business Council, we also update our site regularly with member content, market perspectives, and updates on our programming in Canada and in Southern California. And as we're doing today, we pivoted to more online programming to make sure our community stays connected. Next slide. We have some follow-up contact information here for you, and also this is available in the handout that you can download. So with that, I'd like to thank everyone for attending today. We wish you an excellent rest of your day. Thank you, and stay healthy.